Hi everyone, thank you for joining us at our very first webinar of the year. We're very excited to be back and happy to share some exciting information with you. And again, and obviously we're always happy to have Zerlina with us. She's a regular here on our webinars. And today we'll be talking about the difficulties in the levy collection process. So I think a lot of people do have this problem, and they'll be discussing the different options that trustees have to go through to collect their levies, and they'll also come up with a couple of solutions as to those difficulties that you're facing. Today our speakers are Willie Roos. He's the CEO of Stratafin. He has practiced as a property attorney for over 20 years. He's been involved in sexual title management for over 8 years. He started Stratafin in 2014 with the goal of assisting bodies corporate with their funding without catching them in a debt trap. And Stratafin strives to be a fair and equitable money provider for the sectional title industry. And Zerlina is the co-founder and director of TVDM Consultants. And she is a specialist community schemes legal consultant, offering the services of legal advice in the form of consultations and legal opinions, meeting and CSOS attendances, governance documentation review, and amendments, as well as being a professional trustee. So she is well versed in this industry. Her background is that she is an owner and resident in an HOA and an investor owner in sectional title schemes with a previous managing agent and a non-practicing attorney. And Zerlina lives and breathes community scheme living and absolutely loves it. Excuse me. I'm going to hand over to Zerlina now.
No worries. I really do love it, Daniela. You don't have to say it under your breath and cough like that. She loves it. No, she doesn't. I really do love it. And it's always so great to work with Willie and Daniela because they both share such a passion for this industry as well. Although we come from different walks of life and focus on different things in this industry, we always are able to waste quite a lot of time just talking about things and how we perceive things. And we generally are on the same page as well. So I always am very, very grateful for an opportunity to work with them. And it's always so great to be able to see the same faces and see some new faces as well. Although on the webinar, unfortunately, we can't see your smiling faces, but we most certainly are very, very happy to be chatting to you today.
Zerlina, yes. I actually forgot on my coughing fit, I forgot that I wanted to put a poll up to ask people who they are. So I'm going to launch the poll now quickly. Just asking you who you are. Are you a trustee, managing agent, or an owner? And you can choose more than one option. So if you're more than one of those, go for it.
Yeah, it gives us a good idea who we're talking to and how we must focus our information.
Exactly.
I was doing a similar talk about 2 weeks ago or so in Bloemfontein, and we realized that lots of the people at the NAMA training session at that stage were more owners and trustees. So we have to more focus it towards owners and trustees than managing agents. So it's important for us to know who they are, and then we can try and focus our discussion more towards that specific group. But we do try and accommodate everybody in our discussion. I'm also going to try, Zerlina. You and I have had a long chat this morning already. Instead of preparing, we were talking. So I want to do the similar thing that we did, just have a long chat. I mean, we're going to go through all the slides and whatever, but I definitely want us to have a chat about things because there's so many interesting things that you're experiencing and what we are experiencing, and we can share that with everybody. And then I also just saw that Rudy was on, Rudy Yearshop. Welcome, Rudy. He's one of the leading sectional title attorneys also in the country, so I'm happy to have Rudy here as well. Thanks.
Yeah, so I think it's a pretty decent split between trustee owner and managing agent, with managing agent being a little bit higher. So it's nice to see that. It's nice to see a lot of different people from the industry joining us. And Zerlina,
Fantastic. All right. So unfortunately, I've got the boring topic today, just the nuts and bolts of what the Sectional Title Schemes Management Act says. That's a little play on words there with the nuts and bolts. We know there's quite a nice training session in regard to nuts and bolts and the 101 of sectional title that you can go have a look at as a managing agent. But Willie and I were chatting about, what is a body corporate? And we very often in our consulting practice have owners come to us to say, the body corporate doesn't want me to do this. The body corporate doesn't want me to do that. Or the body corporate says I must do X, Y, Z. Every single member of a body corporate forms the body corporate. It is often confused with the trustees of the body corporate, which is the duly elected representatives of the members of the body corporates. And, the functions and the powers of the body corporate as it's set out in the Sectional Title Schemes Management Act is actually exercised and performed by the trustees. The trustees will then delegate those functions and powers to an extent to managing agents, to attorneys, to accountants, to auditors, even to members on subcommittees or their fellow trustees in regard to portfolios. But as Willie reminded me this morning, the responsibility always rests with the trustees. And then, of course, ultimately, the responsibility rests with the body corporates. And Willie is going to be talking about an incredibly interesting topic, something that we very often receive a question on, and I always refer to Willie being the expert in regard to levy collection, and that's prescription of levies and whether or not prescription applies. And I'd like you to keep at the back of your mind the concept of a body corporate and the responsibilities of the body corporates in this regard, because that is going to play a very big role in whether or not prescription applies to levies and other charges that are raised by the body corporates. So the trustees are the body that are actually undertaking the work, and one can compare it to ownership in a sectional title scheme where an owner might be a corporate entity such as a company, a CC or trust, but it is actually a trustee or a member of that company or director or an employee that is the one that attends a meeting and votes at the meeting. Obviously, the company can't toddle off to a meeting and vote, so it is the person that is representing that entity that is the one that is actually undertaking the work. So the trustees are the ones that are undertaking the work. Interestingly, and again, it's something that we chatted about earlier this morning, Willie, as to how little the trustees are actually able to make decisions on under the Sectional Title Schemes Management Act. A lot of what they were able to take decisions on were taken away from them. They're entering into loans, for example, or entering into leases on common property. Those types of things used to be within the trustees' powers, and those have been taken away. So there's very little that trustees actually have the power to undertake in a sectional title scheme. And obviously in a homeowners association, it would depend on the governance documents. Now, one of the things that is relevant for the purpose of today's discussion is the establishment and maintenance of two funds. It is the administrative and the reserve funds. Interestingly, the reserve fund concept is not a new concept that was introduced under the Sectional Title Schemes Management Act. It was something that was already there under the Sectional Titles Act. The Sectional Titles Act used to provide for reasonable future expenses in regards to maintenance and remedial work of common property. So the concept of saving money for a rainy day is not a new one. And my colleague, Dr. Karen Durham, always said that South Africans don't like to save for a rainy day. We much rather prefer to worry about that problem when the problem arises. So you have to remember that you need to establish and maintain two funds, an administrative fund and a reserve fund. The amount of the reserve fund is not a thumbsuck. And Willie, that's again something we spoke about this morning with regards to budgeting, but the reserve fund is calculated in accordance with the maintenance, repair and replacement plan, which is a moving goalpost. It's a 10-year plan that every single year has to be updated, tabled to the members for approval via an ordinary resolution along with the budget. The reserve fund budget, in my opinion, cannot be approved without a 10-year maintenance, repair and replacement plan. And interestingly, almost 5 years down the road, very often I attend annual general meetings where the maintenance, repair and replacement plan is not only not tabled for member consideration and approval, but has not even been prepared the first time around. So I used to be able to make excuses for clients. Unfortunately, no longer are those excuses acceptable. Every single sectional title scheme has to have a maintenance, repair and replacement plan, unless, of course, you're a brand new body corporate that has literally just had its inaugural general meeting and does not have any requirements for maintenance and remedial work just yet. So that is the tale of two funds, the administrative and the reserve funds. The administrative fund deals with just that, the daily operational expenses of the body corporate, including maintenance and repair. The reserve funds deal with maintenance, repair, and replacement of existing common property infrastructure that is required in the future, that rolling 10-year period. The next thing, after the establishment of these funds, and of course the opening of the bank accounts, plural, the trustees have to require, in other words, compel, force, undertake the duty to recover members to make contributions. Interestingly, and it's something that I'll touch on a bit later, is that although there is a responsibility on behalf of trustees to recover levies, nowhere in the sectional title legislation is there a requirement or the responsibility or duty of owners to pay levies. And very often a clever attorney has said, show me in the act where it says that an owner has to pay levies. That's an interesting one. I think that needs to be inserted there. It's an obvious fact that if you are going to be a member of a body corporate, you are compelled to pay levies, even if you're not contributing, or rather using and enjoying a certain aspect of the common property, you still have to pay for it. If you live on the ground floor and you don't use the elevator, I suggest you jump in at least once a day because you still have to pay for it. If there's a swimming pool and you don't swim, I suggest you at least go and sit by it because you still have to pay for it. The only time you do not contribute towards it, if your body corporate has a rule, more than likely in the management rules, that say that you are excluded for a justifiable reason from a certain element or elements of expenses relating to the common property of the body corporate. So what are these contributions? We very often refer to contributions as levies. Interestingly, the Sectional Title Schemes Management Act has changed that. It is contributions levied, and not levies per se. Above and beyond levies, you also have contributions towards exclusive use areas. Exclusive use areas are still in its nature common property, and of course there are expenses relating to those areas, and those exclusive use area contributions have to be raised to recover the expenses of the body corporate in relation to those parts of common property. And then of course the very arguable special levies that are raised, and many body corporates are of the belief that because there's a reserve fund, or rather members are of the belief that because there's a reserve fund, a healthy one at that, there's no longer going to be the need to raise a special levy. But that's quite incorrect, because the reserve fund is only to be spent in terms of the maintenance, repair and replacement plan unless there's an emergency by trustee resolution, and the reserve fund is only for maintenance and repair and replacement of existing common property infrastructure. So there's still a lot of leeway for special levies to be raised in the body corporate. Special levies, of course, cannot be raised to boost the budget if the budget has been unfortunately under recovering for the expenses of the body corporate. The other item that we don't like to pay, but we have to pay, and I've recently written an article about this, and Shirley Bailey has done a report on expenditure at the Community Scheme Ombud Service that might result in some of us deciding not to pay our CSOS levies, but just a reminder that it is a statutory contribution that has to be made. It's that levy that is payable every single month by every single owner in a sectional title scheme if you are not exempt, and if your levy is more than 500 Rand, recovered by the body corporates and an HAA and a retirement scheme and all the rest, and payable over to the Community Scheme Ombud Service every 3 months. Interestingly, if you've not yet paid a CSOS levy, you are due to pay one as from the 1st of January 2017, and that can be backdated and recovered from you. Another interesting thing that came from a recent CSOS training event. How are these contributions determined by the trustees? Do we simply decide that everybody is going to pay levies equally, or special levies equally, or exclusive use area contributions based on a thumbsuck? Levies and special levies are determined in accordance with your participation quota. Your participation quota is based on the square meterage of your section, not common property and not exclusive use areas. And if the levies are determined any other way, there has to be a rule in terms of Section 11.2 of the Sectional Title Schemes Management Act. And as I mentioned, it's normally in the management rules. It's not a conduct issue, not in the conduct rules. And that rule might say that the levies are to be recovered equally, or one section pays more than another because of a certain reason. For example, the commercial section will pay more towards security because security spends most of its time guarding the commercial section, or the commercial section will be excluded from the payment of levy towards the elevator because the commercial section is on the ground floor, something along those lines. That rule can be quite creative, and it's a lot of fun to draft those types of rules. So if you have any questions in regard to that, you're more than welcome to give us a shout. But if in In the absence of such a rule, a levy and a special levy is calculated in accordance with participation quota. The exclusive use area contribution, of course, is recovered only to defray the expenses of the body corporate actually incurred to deal with that specific part of the common property. Something else that the body corporate has to do, rather the trustees do, and in most times this function is delegated to the managing agent and to the financial department of the managing agent, and that's the preparation of the budgets. And of course, the maintenance, repair and replacement plan in most instances are prepared by the experts in the field. These both have to be approved by the members at an annual general meeting. Interestingly, the maintenance, repair and replacement plan can be approved at a general meeting, which indicates that it's not only done at an AGM, but an SGM as well, whereas budgets need to be approved at the annual general meeting. Of course, this line item at an annual general meeting should, again, in my opinion, be dealt with following consideration of the annual financial statements. A reminder that the item of annual financial statements is not a voting item for the approval of members. It is the trustees that approve it. And interestingly, financial statements do not need to be presented to the members in its audited format. A general meeting or special general meeting can be called after the annual general meeting to deal with audited financial statements. It just doesn't make logical sense to have to do that, especially when quorum and attendance is such a problem. So you would first look at the year that has passed, what those expenses actually were, before you look at the estimate. As Willie and I spoke about earlier, a bit of a thumbs up, because of course we can't budget for actuals. There's always going to be a little bit of over recovery and under recovery, and of course restrictions that might be placed by members in regard to how their budget may actually be exercised. So that's something that the trustees do. Daniela, we can pop off to the next slide.
Before we go over to the next slide, I just wanted to ask a question that's come through because we're talking about trustees. Who determines the interest rate and how often must this be communicated?
Very good question. So it's the trustees that determine an interest rate. It's by a trustee resolution. And of course, any trustee decision can be reverted to the members by an ordinary resolution. So something that can happen at the annual general meeting is that the members, by a directive or a restriction, can actually tell the trustees what they want that interest to be. But again, it has to be recorded in the form of a trustee resolution. And although a trustee resolution is a decision that is taken either at a trustee meeting or via round robin, interest determination is actually one of the things that the Act requires, an actual written trustee resolution. And that trustee resolution, I'm sure Willie will touch on, is very often required to be submitted as part of the levy collection proceedings in court. So it's very important to have that trustee resolution for interest. And of course, that interest rate is capped in terms of the Sectional Title Schemes Management Act. It is something that needs to be done annually because, of course, the budget changes annually and the trustees change annually. So that's an annual trustee resolution, and of course it's a trustee decision in regards to the interest.
One more question, and sorry if I'm missing some questions as we go along, I'll answer them later on just so that everyone knows. Someone's asked here, what is the usual managing agent role / obligation to monitor and track through on levy payers running into arrears, as opposed to only reporting the monthly arrears and expecting trustees themselves to do the detail to follow through on reminder letters, etc., etc.?
Such an important question. So I don't like the word obligation because there is no obligation on anybody that is not based in statutes, in my opinion, but that's just a definition of the word. When it comes to the responsibilities of the body corporate, and I mentioned it at the beginning, Willie reminded me this morning that the responsibilities of the trustees cannot be delegated. The actual brunt work, the function, most certainly can be delegated, but not the responsibility. So if something has been handed over to a managing agent to do, for example, levy collection, the responsibility still rests with the trustees, which is why the managing agent doesn't make the decision as to who gets handed over, what arrangements are entered into, if any, when an owner gets handed over, when a demand or a final reminder should be put in place. This all needs to be specified firstly in the management agreement that is entered into between the managing agent and the body corporate, signed off by the trustees, either by member decision or by trustee decision. And then, of course, that process needs to be agreed to by the trustees and the managing agent. Very often, managing agents only deal with friendly reminders, a telephone call here or there, an email here or there. But when something reaches the stage of a final demand, that is when it gets handed over for legal proceedings or for an attorney to collect either through court or through the CSOS, as Willie will discuss. There is a provision in the Sectional Title Schemes Management Act under the management rules that speaks about the final demand that comes from the body corporate and what that final demand has to include. So it is possible for the body corporate via the managing agent's office to deal with that final demand. But of course, as we all know, if a letter comes from the managing agent or the trustees, we're unlikely to open it or be scared by it. But if it has to come from Rudy's offices as lawyers and legal eagles, oh my goodness, we're definitely going to act on it immediately, because now things have gotten quite serious. So I always recommend that that process is being dealt with by the attorneys appointed by the body corporates, but it's not necessarily something that has to be done by the managing agents. There's a terrible misconception in the industry that when you appoint a managing agent, the managing agent must do everything, and the managing agent is the one responsible for everything, and if anything goes wrong, it's the managing agent's fault. That's not the case. The responsibility is still with the trustees, but of course the trustees are not going to know what is going on in the scheme if that information is not provided to them. So the arrangement and the agreement between the managing agent and the trustees need to ensure that the trustees at all points in time either have access to or receive the financial information of the body corporates in order to ensure that the processes are run correctly and that they're able to make the proper decisions. Of course, not every single trustee is going to be financially minded. I'm not financially minded, so I would never volunteer to have the position of a financial trustee, which is why, again, the right trustees have to be appointed and the guidance of the managing agent has to be taken. And in that regard, you need to make sure that you've got a good relationship with your managing agent and they are suitable to the management of the scheme, especially in regard to financial management. I think that was a very long-winded answer for the question, but I hope it did answer it. All right. So we spoke about the trustees having a fiduciary duty to collect the contributions levied, but interestingly, the Sectional Title Schemes Management Act does not say that the owners have to pay. So that would definitely be my suggestion for an insertion into the Sectional Title Schemes Management Act. It is actually a proposed amendment that we've already sent through to the Community Scheme Ombuds Service when they asked for it. Something I hear very, very often, and I'm sure Stratafin has as well, is I'm not happy with that decision. I'm not happy that the trustees are not allowing me to keep my pets. I'm not happy that the building has been painted pink. I haven't gone to an annual general meeting yet, so I'm not happy with the budget that has been raised, or there hasn't been an annual general meeting yet. I'm not going to pay my levy, or even better, I'm going to pay my levy into a trust account of an attorney and not to the body corporate because I don't trust them or the managing agent in the financial management of my scheme. There is no authority in terms of the legislation for any owner to withhold payment, even in the event of a legitimate dispute. And interestingly, the Community Scheme Ombuds Service, when they first originated and they spoke about levy collection proceedings through their offices, they spoke about a fast-track process in the event of levy collection where there is no dispute. So a dispute would be, and a legitimate dispute would be, no budget has been approved by the members at an annual general meeting. An annual general meeting has not taken place for the last 3 years. We've approved a reserve fund, but we don't have a maintenance, repair and replacement plan. The trustees have raised a levy increase that is contrary to the budget that was tabled and approved. The trustees have raised a levy increase without a trustee resolution. If, for example, the excuse is I haven't received a monthly levy statement, I'm not paying my levy, that's not a legitimate dispute at all, because interestingly, there is no requirement for a levy statement to be sent to the members. There is a requirement that a notice be sent to the members in regard to the budget approval and levy increase, but the levy is due and payable as from the passing of the trustee resolution and not from the date of the notice. And Willie is going to touch on that as well. I don't know, Willie, if you want to say something about that at this point in time or reserve it for later.
I can have a chat about it later on. I mean, we're just going to briefly touch it, but yes, we will chat about it when we get there.
Okay. My colleague Karen Durham wrote on all things special at one point in time a couple of years ago, because we very often used to get the question as to whether or not special levies required a special resolution. One would logically think that it would, but interestingly, a special levy has always required only a trustee resolution, and the determination of the levy in terms of the budget is something that the trustees put together, approved by an ordinary resolution of the members, but ultimately due and payable as from the passing of a trustee resolution. So So very important to have a look at what type of trustee resolutions are required and to actually have those documents as part of your body corporate records for when the proverbial hits the fan and you need it. We spoke about the notification to members, and Willie confirmed that he will touch on it a bit later. The levy is due and payable as from the passing of the trustee resolution, and if levies are not paid, normally on the 1st of the month for the month in advance, then the body corporate has to ensure that along with its managing agent, if it has one, that the processes are put in place for proper levy collection. I always had a situation where trustees entered into payment arrangements, felt sorry for owners, gave people a bit of a levy holiday or a break, or took into consideration their personal circumstances. One must remember that a body corporate is not a business. Its only form of income normally is through levy collection. It can, of course, also have, like lease, for example, of a common property that brings in some collection, but normally it's only the contributions levied. So one cannot afford in a body corporate to be lenient in regard to non-payers. And it needs to, via its trustees or member directive at an annual general meeting, dictate to the trustees and then to its managing agent how it wants the levy collection proceedings to run. The levies are due and payable on the 1st of the month for the month that it is incurred. Perhaps on the 7th day of the month, the levy is considered to be late. Perhaps round about that week, a friendly reminder is sent to an owner. Perhaps at the end of that month, a paid-for reminder is sent to that owner based on the Debt Collectors Act and regulations. From that point in time, a decision quickly needs to be made whether or not the amount that is in arrears and the excuse for non-payment would justify instituting legal proceedings. The quicker those legal proceedings step into play, and I'm sure that Willie and Rudy and the rest of the levy collection attorneys on the line are quite sick and tired of being blamed for long legal processes, when in fact the body corporate actually sat on that debt for way too long before it instituted legal proceedings. So it's very important to have a guide in place to follow and to not be accused as trustees of perhaps having a friendship or a little bit too soft heart in a situation that can prejudice the body corporate. If those legal proceedings do take place, it's very important to remember that under the old Act, the Sectional Titles Act, you used to, as a body corporate, be able to recover legal fees, no questions asked from an owner. You would just raise it on the levy account and off you go. Now, under the Sectional Title Schemes Management Act, under the prescribed management rules, legal fees need to be agreed, or it needs to be subject to an order, and then, of course, it needs to be taxed. Now, I have yet to meet an owner that has agreed to pay legal fees. Of course, as part of payment arrangements, they most certainly can agree to it, but in my experience with levy collection years and years and years ago, and of course, Willie can confirm or deny, very often the first thing that's asked to be written off the account is the legal fees, followed by the interest, and followed by any administrative charges before they start getting into the meat of the actual capital amount, the levy. So it is very important to remember that in order to recover the legal fees from the owner, other than going through the court process and of course getting a court order for costs, is to actually amend your management rules to allow for it. Now, in my opinion, the CSOS is being a little bit naughty in not approving management rules that the members have correctly amended to allow for the recovery of legal costs. Now, it is something that we are still debating with the Community Scheme Ombuds Service, and we honestly haven't gotten a straight answer in regards to it. Now, it's my opinion that when it comes to amending your management rules, amending your conduct rules, of course, they have to be reasonable. Of course, they have to apply equally to all owners of sections, not necessarily to the purpose to which the section is put, as per the old Act. And it has to be justifiable. It needs to be constitutional. It needs to be suitable to the scheme. But when it comes to something as severe potentially as the recovery of legal fees, how is it fair or reasonable or even constitutional for the body corporate as a whole to have to pay for legal fees that are incurred due to one owner, legitimately or not, withholding payment of their levies? Now, I don't believe that there is a legitimate reason to withhold levies, even if the levies are being horribly miscalculated. You need to pay your levy and then, of course, dispute and deal with the real channels or the right channels of dispute resolution. So wherever we are instructed, which is not very often because it is incredibly difficult to get a unanimous resolution, we do amend management rules to provide for the recovery of legal fees. We have not yet been turned down by the Community Scheme Ombuds Service. However, what is happening is, although the trustees and managing agents are approaching us to amend the management rules, they're not able to get the required quorum of 80% at a special general meeting or at an annual general meeting to actually table the unanimous resolution. We have recently put out a survey or a poll where we've asked trustees and managing agents in the industry, and if you haven't had sight of it, please do contact us and we'll send it to you, how often you're actually able to get a quorum of 80% to pass a unanimous resolution, bearing in mind that for a unanimous resolution, you cannot proceed at the second or the adjourned meeting with whatever quorum there is. You always have to get 80%. And the Community Scheme Ombuds Service put a practice directive out a little while ago, I think it was March last year, where they said, provided you can get 75% vote in favor of a unanimous resolution versus 100%, you can approach the Community Scheme Ombuds Service. But the issue is not the amount of vote that is acquired, it is actually the quorum that's the issue. So we are needing to continue in our fight with the Community Scheme Ombuds Service to deal with not only the quorum requirements, but of course the issue of non-approval of management rules due to the practice directives that they put out. Now, if any of you are bored and have the time, go and look at the Community Scheme Ombuds Service Act, all the sections before Section 38, because for most of us, the Act only starts at Section 38 in regards to the applications for dispute resolution. The remainder of the Act deal with the functions of CSOS, the functions of the board, the role of the board, and of course, practice directives. Now, practice directives are issued, in my opinion, left, right, and center, sometimes correctly and sometimes not. Practice directives are not there to amend the Community Scheme Ombuds Service Act or the Sectional Title Schemes Management Act. Practice directives are there to interpret and to clarify provisions of the Community Schemes Ombuds Service Act that is already there. And what the practice directives are doing recently is amending the legislation, adding to the legislation, deleting the legislation. And one of the things are the undesirable rules and when CSOS will accept rules or not. And this is where the legal fees argument come in. So it is something that is still going to become quite prevalent in the industry in regards to discussions. And I'm sure people are going to get quite sick and tired of the likes of me, harping on these issues, but it is time that a change is made. Now, I mentioned that the trustees are the one that make the decisions as to how to institute action against non-payers, and the routes that can be followed is the Community Scheme Ombuds Service Act, Magistrates Court, and High Court. Now, this is where the expert Willie is going to come in. The only thing left for me to say is that when it comes to processes through the Community Scheme Ombuds Service, I'd be very interested in the chat function to see how many people do hand over the levy collection matters to the Community Scheme Ombuds Service. The body corporates, trustees, and managing agents that I speak to very rarely, if never, hand over matters to the Community Scheme Ombuds Service to deal with in regard to levy collection. And when they have, they've been unsuccessful, either because the processes is not correct, alternatively because of the long delays. So it seems as though the court is most certainly still the way to deal with these processes, but Willie will tell you about that a little bit more.
Thanks, Zerlina. I'm going to try and be a bit brief because I see that we've gone half an hour already, and and thank you for that. I mean, you've got so much. No, you've got so much knowledge, and we love to listen to all the stuff that you say. So let me just start quickly regarding interest. Management Rule 21 requires interest to be determined by the trustees. So the trustees will determine the interest rate applicable. We're not 100% certain as to what the maximum of that interest rate can be. Zerlina will tell you that there is a directive that says it should not exceed the maximum as per the what is it? Incidental credit. I think it's incidental credit. It does not say that in the Act. So that is one of those things where CSOS has made a determination as to what interest rate is applicable. And that currently is at 2% compounded monthly in arrears, so it's slightly more than 24% that can be charged. Interest is payable from the moment that the amount becomes in arrears. So you can give leeway where you say, like Zerlina said, that interest can only be charged from the 7th or so forth. But in general, the levy is payable by the first day of the month for that coming month. And as such, interest can be charged then from the second day if that levy is not paid. So it is not, you don't have to wait until the 7th or the 14th or the 30th of that month to start interest charged. So that just regarding interest. Then quickly regarding budgets, I think what we see from Stratafin's point of view when we do due diligences on bodies corporate is that very few bodies corporate does budget for legal fees. Legal fees needs to be paid out of the administrative budget. So therefore there need to be a budget for legal fees if you want to pursue a debtor through the legal channel. So if you want to go through the courts, then you require money. If you're going to go through the CISOS process, then obviously you can get an adjudication order from CISOS, but from that moment forward, you will have to proceed through the courts, and they will it will require funding for that as well, because you're going to need an attorney to do the warrant of executions, to proceed if there's a nulla bona, to then apply to the court in terms of Magistrates Court, the Magistrates Court Act, Section 66, or High Court Rules 46 for the right to sell that property in execution. So you will require funding unless you know how to manage this process yourselves. I was explaining to Zerlina all the problems that we have experienced in the last couple of years in the courts, and I can tell you now we're sitting with lots of attorneys and lawyers here in Stratafin and with the attorneys, panel attorneys, and we're scratching our heads some days to find a way around these orders that are made by courts. One of the ones that Zerlina has touched on was the requirement that a notification has to be sent out to owners prior to judgment being granted, or that the court will grant judgment in those matters. That stopped the collection of levies for a considerable period of time in the magistrates courts, where the courts then refuse to grant that unless we can prove that the trustees have sent out, or the managing agent on behalf of the trustees have sent out these letters. Luckily, that has now been dealt with in a High Court matter where a full bench decision has said that that is not a requirement for the collection of levies. It's an administrative duty and something that the trustees must do in terms of the management rules. However, it is not a requirement for the collection of levies. So as such, that is no hindrance any longer, and we can now proceed to collect on that basis. I said to Zerlina, I will make the case available to her, but anybody else that require that, we will make that available to you guys. Collection through CISOS, we hear every day that CISOS is for free. I cannot understand how anybody can think that. If everybody pays CISOS a monthly fee, how that is for free. It sounds to me as if they are a place that makes a lot of money to deal with people that are not doing what they're supposed to do, and everybody else, including those that are compliant, needs to pay for that. Don't know if that is fair. In my mind, it's not. I would rather want to have the rules of a scheme amended so that we can recover the full legal fees from the debtor that has not complied with his obligations. Zerlina has touched on the problem to get those rules approved, that you need a unanimous decision. I think that role players in the industry needs to speak to developers that once they establish these schemes, that the rule be changed immediately and be implemented as part of the amendments that the developer is entitled to make when he set up that scheme. So I think it's important that we as the role players in the industry make the developers aware that they can change the rule and they can build into the rule the collection fees, and that be allocated to the owner's account that has not complied. So that's important. From CISOS's point of view, Stratafin does not do a lot of collections through CISOS. Where Bodies Corporate has proceeded with CISOS collections, we proceed with those, but obviously you can only get to a adjudication order, and once you get to an adjudication order, then you need to go back to the courts and complete the process through the courts. So we think it's a futile process to go one step with CISOS, and then the balance of the collection process through the courts. The majority of fees in any event in respect of a collection matter sits at the end of the matter when that property is sold in execution, when you have to apply to the court to get the right to sell that property, and then to proceed to advertise the sale of the property, and then to do the sale, and then recover the money from the sale in execution. I would think about 60% or 70% of the fees, of the attorney's fees sit in that last part of the process. So the amount that is saved by getting an adjudication order is minimal. It's not really something to write home about. We find also the process through CISOS has got inherent risks. Obviously, the first thing is that it is not appealable on fact. So where CISOS has made a mistake on fact, you are bound by that. I have advised on a matter regarding incorrect electricity charges, I think in the last 2 or 3 weeks, and there CISOS made an order that the charges were not incorrectly charged, although they were, and that's a factual position. One now sit with that problem that you can't do anything about that, so you're stuck. So from my point of view, we see lots of factual mistakes by courts, and then it is appealable, and you can remedy that and rectify that throughout the court process. You can't do that through CISOS. The other big problem that we find with CISOS is the application of prescription. CISOS mero moto applies prescription, so they immediately, what is older than 3 years, deduct. Or so we understand, and luckily for us, we have not had that through them. And that is immediately deducted, and then the order is granted only in respect of those debts that are not older than 3 years. So prescription is not a simple matter. It is not as simple as that. Obviously, if there are payments made during the process, then those payments is an acknowledgement of the amount owing, and one should then not apply prescription at all. But there's also the workings of Section 3(1)(b) and Section 13 of the Prescription Act, that says that if a person is a member of the governing body of a corporate body, then prescription is suspended until such a time that the person is no longer a member. Can you hear me? Am I gone?
No, we can hear you.
Perfect. So in that instance, a person that is a member, so all owners are members, prescription is then suspended until they unbecome a member. You can only unbecome a member once you sell your property and you have obtained a clearance certificate in terms of Section 15(b)(3) of the Sectional Titles Act, or you have made an arrangement for the payment thereof to the satisfaction of the body corporate. So in that instance, the body corporate should then also get their money. So from our point of view, levies do not prescribe. We will discuss it a bit more in depth later on, if we've got the time. And the other thing that also is a problem with CISOS is that Section 17 of the Prescription Act says that no court shall apply prescription mero moto. So that means that a debtor must claim prescription. A debtor must then come and say, I want prescription to be applied, and he must put the facts in front of the court that then proves the prescription of that debt. What CISOS does by applying prescription mero moto is they just cut off at 3 years. They don't look at any other facts around that. And they are in contravention of the Prescription Act, because they are not supposed, they are at the same level as a high court, so they're not supposed to do that. They should not apply prescription. So that is a problem, and that needs to be remedied, because bodies corporate can lose a lot of money if that is just applied like that. I can just say from our point of view, we've got thousands of debtors throughout the courts in the country, and we have never had a matter where a court has applied prescription on its own and where prescription has been granted. We've not had a matter where prescription was actually pleaded and actually gone through. So it is very difficult for somebody to actually prove that a debt is prescribed, and we've not had a matter that we could take on appeal to actually test our our theory in respect of prescription and the case law that is around. It's the Greenwood Village matter that I always punt as the matter. It's a matter of the Pietermaritzburg High Court that says that the owner is a member of the corporate body, and as such, prescription is suspended. So it's the same argument that I've just made above. So we've not had a matter where we actually could take that on appeal, but it is obviously something that we would take on appeal if that becomes necessary. Okay, like I said, the collection process is a very costly process, and therefore the body corporate needs to budget for it. A collection matter we see, if you go to attorneys that specialize in this, can vary anything from 60,000 to 120,000 Rand up to a sale in execution. So that is an enormous amount of money in respect of legal fees, and that is on an attorney and client scale. In terms of the old act, all that cost could have been recovered from the debtor. Now it's not possible unless the order is taxed or the debtor has agreed. Like Zerlina said, we have never seen debtors agree unless they come to an arrangement, and in that acknowledgement of debt, they would then agree to attorney and client costs. But in general, you will not get a debtor to agree to an additional 60 to 120,000 Rand. If you tax that bill, we see them taxed for about 30 to 35,000 Rand. So therefore, the balance of that between the taxed amount and the amount charged by the attorney would be an attorney and client cost, which will be payable by the body corporate out of the administrative fund, and therefore you need to budget for that. Otherwise, you do not have funding to pay for it. So that needs to go into your budget. We have a budget calculator that's freely available on our website, and it does have that in there so that people can remember to budget for that. Also remember to budget for the shortfalls of payments of levies as well. So do make sure that your budget is not only specifically 100% that you require a month, but that there are some fat in there that you can go through a period where people are not paying, because we see lots of body corporates that actually become dysfunctional when you've got 10% or 5% of the owners not paying, and then security can't be paid, or the council cannot be paid in respect of the services rendered by the council. Then that gets cut off, and the moment that happens, that scheme becomes dysfunctional and your property values plummet. So make sure that you have sufficient cash flow as well. An unopposed matter takes approximately 24 months. I mean, we've got thousands of matters, and I can tell you now we track them daily. It takes 24 months on average, and that is where we manage the process. I think Rudy can come up there and can tell us as well, that is the situation. 24 months for an unopposed matter from when issuing summons up to the sale and execution of that immovable property. So you must know that if an owner is not going to pay, you're going to be without levies for 2 years. If that matter is opposed for some or other reason, and in general, we see that those defenses are frivolous, they will not go through a court, and at the end of the day, a court won't uphold them. But that matter can take anything from 3 years to 5 years to finality, as the court system works currently. We also see lots of difference in experience in the different courts. Obviously, the magistrates' courts are the lowest tier of the courts, and the experience in respect of dealing with levy matters is far less than that in the High Court. But obviously, when you move a matter to the High Court, it is far more expensive. So we look at moving all our matters through the High Court rather than the Magistrates' Court. Also, that creates problems if there's a bond over the property. The bondholder, if the bond is not in arrears, the bondholder will then require a certificate of balance, which is equal to the amount owing to them. And one will have to go back to court on a couple of occasions, and every application to change the reserve price will take you approximately 6 months. So if there's a bond over the property, it will definitely take longer to collect that levy amount as well. However, it does not stop the collection, you will be able at the end of the day to get to a sale in execution. I'll quickly want to touch on the Mars Rose matter, where we now are experiencing a problem with the embargo as envisaged by section 15b3, that an owner can stop to be, or that an owner cannot transfer until all amounts are paid. That matter states that if the property is sold in execution and the levies are not recovered from that sale in execution, then the body corporate cannot go back to the new purchaser and require payment by the new purchaser of that amount for them to pass transfer. One will have to pursue the old debtor. That matter is on appeal, and we are actually having a meeting this afternoon again about that, where we are trying to overturn, as an industry, trying to overturn that decision, because that will have huge ramifications on bodies corporate if they can't recover their levies. So in general, the collection process is quite complex, and I would think that it would always be better for a body corporate to rather get experts involved to do the collections rather than managing the process themselves. I mean, as I said, with experts being involved with it, we are sometimes stumped by the decisions of the courts in this regard. A managing agent can collect the outstanding levies, but obviously then they have to be registered in terms of the Debt Collectors Act, and only under those circumstances will they be entitled to put their fees onto, or debit their fees onto, the account of the debtor or the owner. We from our point of view, when we do due diligences, we see that these amounts are put onto the accounts. The problem with that is that you will not be able to recover that through a court of law. When you require a default judgment, the general ledger is required, and the court want to have a look at the amounts that's put on there, want to see that those amounts were raised in accordance with the legislation. So where you've debited the account with unauthorized charges like legal fees prior to taxation, the court will not grant order in respect of that, and that will be deducted from the amount. So you can't recover it. It's not recoverable. Okay, prescription, a bit more about that. Prescription is a legal principle in terms of which the debtor's liability to pay an outstanding debt is extinguished or suspended after the passing of a prescribed period. This will only apply if the debtor has not acknowledged his liability. So I said earlier on, the payment of a installment or a levy is seen as an acknowledgement that the amount is owing. So that needs to be taken into consideration. There are different periods for prescription: 30 years in respect of a bond, judgment debt, taxation, monies owing to the state in terms of royalties, in terms of the Minerals Act, 15 years in respect of other debts owing to the state, in respect of loans and sales or leases of land by the state, 6 years period in respect of debts from bills of exchange. We don't really have checks any longer, or negotiable instruments, or notarial contracts. So in general, where somebody has acknowledged his indebtedness, then that will take 6 years to prescribe. All other debts are a 3-year period. Zerlina, you said that monies were paying to CISOs from 2017. I asked a question the other day: what of that is already prescribed? Is CISOS seen as the state, or is it seen as a entity or a separate entity of the state? I think there's an argument to be made, and the case law is available in that respect, that CISOS is not the state, and as such that their debt also prescribes after 3 years. So there is an argument in that respect. So if the body corporate hasn't paid, maybe you can get away with only paying for 3 years of levies. To go back to section 31B and 13, again, I've just said it's where the creditor is a juristic person and the debtor is a member of the governing body of the juristic person. So the question is the member a is the debtor a member of the governing body? And that is the discussion that Zerlina and I had this morning. If you look at section 3 of the Act, the Sectional Title Schemes Management Act, you will see that the powers that are bestowed upon the body corporate must perform the functions entrusted to it by or under this Act or the rules. So the body that actually manages everything is the body corporate. The trustees are then, they then have a delegation of authority in terms of section 7, and they will probably also delegate authority to the managing agent in terms of their contract and require compliance with their contract. But in my opinion, the debtor is a member of the governing body once he is an owner. And as such, the argument is that prescription is then suspended. The Greenwood Village matter and Reddy was a matter of the High Court in Pietermaritzburg. It's only a single judge that found that argument to be correct. So this argument has not been tested to a full bench or to the appellate division, but that case is around, and if anybody requires it, we are more than willing to share that with you guys so that you can have that argument. But if you do your collections through the courts, you will not necessarily have the problem that prescription will be raised. The courts will not raise prescription on their own. The question is also, is a body corporate a juristic person? A juristic person, there must be perpetual succession. It must sue and be sued in its own name. And it doesn't die in the event that a member dies or is no longer a member. So clearly a body corporate, sectional title scheme body corporate is a juristic person. That was also in any event found in the matter of Reddy and Greenwood Village as well. The question then also, who holds the ultimate power? Is it the trustees or the owners? As I said earlier on, section 3, 4, and 5, the actual power rests with the owners. The trustees have got delegated authority from the owners, and the owners can actually manipulate the collection process in the sense that they would not approve budget for that, and the trustees' hands will then be tied. So therefore, the owners do have ultimate power, and as such, I think that is the ill that section 3.1b and 13 try to cure by making sure that the people that have the power do not stop the collection of money against them. And as such, I believe that because the ultimate power rests with the owners, that therefore the Act tried to cure that ill and say, well, then prescription is suspended until such a time as you unbecome a member. I was asked also, I see we're almost running out of time, so I'm going to quickly jump over this or get to this. In Duplo, we've got two types of in Duplo in South Africa. We've got the common law in Duplo rule, and then we've got the statutory in Duplo rule in terms of the Credit Act. The difference between the two is that with the common law in Duplo, your interest runs up to the capital, and all payments that are made are first deducted from the interest, and the interest can run up to the capital then again. With the common law in Duplo, your legal fees and your interest runs up to capital, but any payment that comes off there comes off from the double amount, and it cannot run up to the double again. In terms of sectional title, the common law in Duplo is applicable. It's not, our levies does not fall under the Credit Act. It's not an incidental credit. And as such, the common law in Duplo is applicable. So that means that all payments are first allocated towards the interest and thereafter only towards capital and other costs. Okay, so I quickly ran through that. I hope I got through it, Daniela.
Yes, yeah, we got through everything that we needed to get through at a record speed. So thank you so much for that. There have been so many questions that we just have not had a chance to get to, unfortunately. I'm going to copy those into a sheet. I'll get Willie and Zerlina to take a look through those and respond, and then I'll share those answers with everyone so that everyone can see the answers. I also wanted to mention that Zerlina and Willie will be at the We Connect to Property Masterclass on the 23rd of February. And Zerlina will be discussing reimagining the role of the property manager in community dispute resolution. And Willie will be discussing the importance of a rock-solid arrears process, and then practical solutions with that. So what I'll also do, they'll both be presenting on the 23rd, which is, I think, is the Tuesday. I'll share that link, so anyone that wants to go and register for that, you're welcome to go and do that. Okay, and then that's it. That's us. I mean, we're on time, exactly on time.
Thank you so much, Willie and Daniela. Appreciate it.
Thanks,
Thank you.
Zerlina. We really appreciate you coming
Yeah.
along.